So at this time, I'll simply turn things over to Bob Smith, the moderator of this panel. Bob is the managing director of our center, and he's a hardworking and very loyal soul working in these areas. But let me turn things over to him for this session.
Well, we're excited this morning to have this panel to discuss the Obergefell decision, and this is obviously something that's been on many people's minds and wondering about it, and we have some wonderful experts who will guide us through the decision and its implications. Each of our panelists are really a profile in courage in their individual lives in upholding religious freedom. Let me just start with Jean. Jean has an illustrious career as an appellate litigator, having clerked at the U.S. Supreme Court, graduating from the Yale Law School with distinction, and then continuing his practice at primarily at the federal appellate courts and at the U.S. Supreme Court. Much of those decisions that he's worked on have involved religious organizations and their needs. And you may have known from newspaper accounts that about a year and a half ago, he left a very large international law firm to come to Utah and receive an appointment as a special assistant attorney general to assist with the Kitchen versus Herbert case, the first federal decision that mandated same-sex marriage under the federal Constitution. And he has spent a lot of time working on the same-sex marriage issue, both for Utah, for Idaho, and in other capacities. Alexander Dushku is a shareholder and member of the board of directors of the Salt Lake law firm Curtin and McConkie. He has also had great distinction in his academic career, and in coming to Curtin and McConkie has been in the constitutional group that primarily represents the LDS Church in these kinds of issues. Alexander mentioned that he's been working on marriage issues for close to 20 years and has written many briefs, and including the briefs in these cases that were Obergefell and many of the other same-sex marriage cases that have been occurring around the country on behalf of the church, and assisting with many other religious organizations in their brief writing as well. Robin needs little introduction after our experiences with her yesterday and her insightful comments, but I think it's worth mentioning that in this regard with marriage, she's had a long history of working on family law issues and religious freedom issues, and so the confluence of those two things is really her sweet spot, and we look forward to her expert comments today. I think it should be noted that the very first free exercise case in the United States dealt with marriage. It dealt with polygamy in Utah, the Reynolds decision, and so marriage has been a part of the religious freedom framework from really the inception of at least free exercise jurisprudence. And so this is a topic that, even though we're dealing with marriage, it has such an implication on our religious feelings. As we learned yesterday from Matt, religious freedom is important in part because it goes to the core of our identity, and part of that core is our marriage decisions. And so these implicate very sensitive topics, and we're grateful for our panelists who will elucidate those for us. Now, just so you understand, we want to have lots of time for questions. We've asked, however, for Jean to give us an overview of the decision so that we understand its history and background and how the decision was decided. And then he will illuminate some of the religious freedom risks that are possible because of the decision and how it was decided. Alexander will give deeper analysis of the risks and the cultural implications of the Obergefell decision. And Robin will discuss some of the current reactions that we've already seen in response to the decision, and some of her recommendations and principles that we might consider as we consider dealing with that decision. So with that, we'll turn it over to Jean.
Well, good morning. It is an honor to be with all of you and to be able to participate in this conference. I'm going to begin with a question, whether anybody in the audience knows the proper pronunciation of the name of this case. How would you pronounce it in German? Obergefell. Okay. I was a French-speaking missionary, so I'm inclined to say Obergefell. But we'll go, since Cole was and is an expert in German, maybe I'll try to say Obergefell unless somebody objects. Well, since the decision 10 days ago, I've been asked more than a few times whether, having made some professional and financial sacrifices to defend traditional marriage for the last year and a half, whether I felt devastated to see those efforts come to naught in the decision 10 days ago. And I can't deny that the decision was an enormous disappointment. I think it's a tragedy for democracy. I think it's a tragedy for federalism. I think in the long run it is a tragedy for children and ultimately for society. But I have no regrets about taking on the cause or the way we approached it. I have always believed that whether we won or lost the case, those of us who believe in traditional marriage needed to try to leave a persuasive witness of the human and social risks of redefining marriage as a genderless institution, in hopes at least that other nations and perhaps future generations will avoid what I view as a colossal mistake, and perhaps to lay the groundwork for a future Supreme Court to overrule the decision that we got 10 days ago. And certainly the 4 dissenters, I think based on their dissents, would not hesitate to overrule Obergefell if there were an opportunity to do that after a change in personnel on the court. I also felt that it was important to defend Utah's marriage laws and Idaho's and the others that I was involved in defending in a way that doesn't depend upon any particular religious or moral views about homosexuality. I have those views of my own, but I've always felt that traditional marriage can and should be defended in a way that an atheist or an agnostic would find the defense perfectly sensible and acceptable. And I've also felt that it was important to defend those laws in a way that avoids casting any aspersions, either directly or indirectly, on gays and lesbians or on their motives for seeking marriage. Now, going forward, I still think that those of us who believe in traditional marriage should do everything reasonably possible to overturn Obergefell, or at least to mitigate its effects. And as a member of BYU's Board of Trustees recently reminded us, this is from Elder Oak's conference talk a few months ago, he said, "Even as we seek to be meek and to avoid contention, we must not compromise or dilute our commitment to the truths that we understand. We must not surrender our positions or our values." At the same time, I don't think it's right or productive to rail against the Supreme Court majority or our opponents, and especially not to impugn their motives. Here again, I think Elder Oaks gave us some very wise counsel when he said that followers of Christ should be examples of civility. We should love all people, be good listeners, and show concern for their sincere beliefs. And though we may disagree, we should not be disagreeable. Yes, we should be wise in explaining and pursuing our positions and in exercising our influence, but when our positions do not prevail, we should accept unfavorable results graciously and practice civility with our adversaries. And I think, especially in light of the religious freedom issues that we'll discuss in a moment, civility is going to be even more important in this debate. And so today I'd like to briefly describe Justice Kennedy's opinion, and especially his attempts to minimize the risks to religious freedom that he knew his opinion would create. And then I'll describe some of the main religious freedom problems that the decision nevertheless creates or exacerbates, and I'll conclude with a few words about what we can do about those inevitable conflicts, and then the other panelists will have some additional wonderful ideas for us as well. Now, contrary to the argument that we often hear, how many of you heard people say that, well, same-sex marriage doesn't really affect religious freedom, right? If you don't like same-sex marriage, don't marry somebody of the same sex, right? How many of you heard that? Well, Justice Kennedy obviously recognized that there is at least a potential for enormous conflict between institutionalizing same-sex marriage and religious freedom, and that conflict arises from the fact that all three of the Abrahamic religions, Judaism, Islam, and Christianity, and all other major world religions have for millennia taught that a man-woman union is not just nice, but that it's central to the very idea of marriage. Now, a lot of people try to compare opposition to same-sex marriage with opposition to interracial marriage, and they say, well, those religious objections to interracial marriage, you know, they all went away, and religious objections to same-sex marriage will go away as well. Here's a picture of the famous couple that was at issue in the Loving versus Virginia case. The fundamental difference, though, is that, and I went to high school in the South, and so I would occasionally hear people make religious arguments against interracial marriage. But in my experience, those beliefs were never very widespread, and there was never any religious body that I ever heard of, or have heard of since, that ever taught that racial homogeneity is central to the idea of marriage. Nobody ever taught that. But by contrast, all major world religions have always taught that a man-woman union is central and fundamental to marriage. And so, yes, there are a few Christian faiths and a few Jewish groups that have kind of departed from that consensus. But when you do the demographics and you determine, well, what percentage of the population actually belongs to denominations that have accepted same-sex marriage, it's actually a tiny percentage of religious believers. According to my calculations a couple of years ago, it's about 3.8% of the population that belong to denominations that accept same-sex marriage. Yes, there's a larger portion of the population that sometimes doesn't accept the teachings of their own faiths on that subject, but the religions that account for the vast majority of religious believers continue to believe that marriage is fundamentally a man-woman union. And that may be one reason that 3 separate times in his opinion, Justice Kennedy went out of his way to express respect for traditional religious views of marriage, and seemed to offer or seemed to express the hope that same-sex marriage advocates would likewise be respectful of those beliefs. Here's one example. He said on page 4 of his opinion, the view that marriage by its nature is a gender-differentiated union of a man and a woman long has been held and continues to be held in good faith by reasonable and sincere people. Now, he didn't have to write that. That wasn't essential to the outcome that he reached in his opinion. And then later on, a few pages later, he says, many who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. Again, an unnecessary expression of respect for the religious views that he knew he was running counter to, in his opinion. And then finally, you all are probably aware of this paragraph that comes right at the end of his principal constitutional analysis. He says, finally, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precept, same-sex marriage should not be condoned. And then he goes on to say the First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths and to their own deep aspirations to continue the family structure they have long revered. Again, that wasn't essential to his legal analysis or to his conclusions. And by the way, none of the other judges that had ruled one way or another on same-sex marriage in all the litigation leading up to Obergefell, none of the other judges had found any reason to express that kind of respect for religious views. Now, it's true that, as the Chief Justice pointed out in his dissent, that Justice Kennedy's statement here doesn't actually mention religiously motivated conduct. He's talking about speech here. And of course, it would have been nice if Justice Kennedy had talked about the importance of religiously motivated conduct, but for reasons we'll talk about in a few moments, Justice Kennedy has in fact been a pretty good defender of religiously motivated conduct during his career, and so his failure to mention that here I don't think should be taken as any indication that he's just going to rubber stamp attempts by same-sex marriage advocates to override the religious beliefs of people who engage in conduct that's consistent with those beliefs. And so again, of all the opinions that ruled in favor of same-sex marriage, Justice Kennedy's is the most respectful of religion, and not just for the statements that we've read, but also because of the legal theory that it adopted. Now, based on the decisions that had come before, Justice Kennedy, once he decided that he was going to require same-sex marriage as a constitutional matter, he had basically 5 different paths that he could have taken to get there. Okay? One path would be to say that for a state to deny same-sex marriage is based on animus or ill will towards gays and lesbians. And there were a couple of district court decisions, including one in Virginia by Judge Allen, that basically relied on that rationale. Another possible rationale was to say, well, for a state to deny same-sex marriage is just completely irrational. There's no reasonable basis that supports it. That was what a judge who used to be viewed as a conservative judge, Judge Posner in the Seventh Circuit, ruled on behalf of his court. Now, either of those rulings would have been very problematic for religious freedom because they would have suggested that any opposition to same-sex marriage has to be based just on simple bigotry, right? If it's irrational or if it's based on ill will, it's just bigotry, and that obviously would have been a huge battering ram that the other side could use against people of faith. And Justice Kennedy was obviously aware of that. Another approach that Justice Kennedy did not take, in his opinion, was the position that was consistently pressed by the Obama administration and that had been adopted by the Ninth Circuit in a decision by Judge Reinhart, which is the idea that sexual orientation is a suspect class, or sometimes called a quasi-suspect class. If it's a suspect class, then any regulations or laws that would adversely impact gays and lesbians would be treated essentially as equivalent to laws that would adversely impact people based on race. And Justice Kennedy did not go down that path either. And if you think about it, that kind of a ruling could have had lots of religious freedom ramifications beyond marriage. You know, any time anybody did anything that would adversely affect a member of the LGBT community, that could be viewed as as creating constitutional problems. Another approach that he did not adopt was the idea that denial of same-sex marriage constitutes discrimination on the basis of sex. And one of the concurring opinions in the Ninth Circuit decision had relied on that ground. And his final option, which is the option he chose, was similar to the option chosen by Judge Lucero in the Kitchen case that I argued and in which Utah's marriage law was at issue. And that was the idea that there is a fundamental right to marriage under the Due Process Clause of the federal Constitution, and that to limit marriage to opposite sex couples is to effectively deny to gays and lesbians the ability to enjoy that fundamental right. So that was the path that he chose. And although it does create a number of problems that we'll talk about in a few minutes, it's not as bad as one of the other options would have been. So those of us who care about religious liberty can be grateful that as bad as the Obergefell decision was, religious liberty at least dodged some big bullets. But the opinion, unintentionally I think, launched at least 12 religious freedom grenades that are still in the air, and I'll call those the dirty dozen. And they fall into two categories. One set of grenades would threaten individual religious liberty, and another set would threaten institutional religious freedom. And to be fair, in many cases, the Obergefell decision didn't actually create the problem, but it exacerbated a pre-existing problem. So let's talk briefly about threats to individual religious freedom, and I'll run through those quickly since they've been discussed at some length earlier in this conference. One obvious threat is to professional counselors who could well be forced, either by state law or professional standards, to violate their religious beliefs by, for example, assisting a same-sex couple in preparing for marriage. That was a risk that was much lower before Obergefell. Another risk is a risk to other professionals like lawyers or business executives who express or belong to organizations that teach the traditional view of marriage. And the risk there is that, like Brendan Eich of Mozilla, they would be excluded from certain kinds of jobs. And I think many of you are aware that the California Supreme Court recently adopted a rule that said that judges can't be a member of the Boy Scouts of America. One could well imagine rules like that being adopted around the country that preclude judges from serving if they belong to religious or other organizations that teach the traditional view of marriage. Another threat to individual liberty is to school teachers who could well be forced to violate their religious beliefs by endorsing the idea that a same-sex union is as legitimate a way to form a marriage and family as a man-woman union. Another threat is to parents with children in public schools who could be denied the ability to opt their children out of instruction about marriage and family that contravenes their faith. And once again, that was a problem already to some extent, but now that we have a Supreme Court decision that says same-sex couples have a constitutional right to be married, that makes it easier for school officials to deny parents the ability to opt their children out of programs that would teach that. And of course, we talked yesterday a little bit about the problems faced by clerks and justices of the peace and other public officials who are involved in marriage. Are they going to be required to violate their religious beliefs in the issuance of marriage licenses or even the performance of marriages? And then, of course, there are the threats to wedding service providers, the butcher, the baker, the floral arrangement maker that we've talked about before. The risk there being that they will effectively be forced to participate in a ceremony that violates their religious beliefs. And once again, that was already a problem even in states that don't have same-sex marriage. The famous New Mexico case involving the wedding photographer was in a state that didn't have same-sex marriage. But having a U.S. Supreme Court ruling that says there's a constitutional right to same-sex marriage is just going to make those kinds of problems proliferate, or at least increase the risk of them. Now, to its great credit, Utah earlier in the spring largely handled the first 5 of these problems in the laws that were enacted there. And the last one, that is the wedding service providers, really isn't an issue in Utah at the moment because Utah doesn't have a so-called public accommodations law that would allow somebody to sue someone who denies them photographic services or refuses to bake a wedding cake for them or something like that. But all 6 of these issues are likely to be big problems in many other states for some time to come. Now let's spend a moment talking about potential threats to religious institutions. And here, most of these problems arise not just under state law, but also under federal law, which of course means that Utah's recent law can't fully protect religious institutions that are headquartered here in Utah. Perhaps the best place to start is with the issue that Justice Alito raised during the Obergefell oral argument, and that's discussed in the opinion, and that is the prospect of the federal government or state and local governments revoking the tax-exempt status of institutions that dissent in word or deed from the new orthodoxy that equates same-sex marriage with traditional marriage. During the oral argument, as I think most of you know, the U.S. Solicitor General, Don Barilli, answered Justice Alito's question by saying, "You're right, Justice Alito, I can't deny that that's going to be an issue. That's going to be an issue." And then, of course, the administration's failure to walk back from that after the oral argument, to me, suggests that there are people within the administration who are actively considering doing just that, and revoking the tax-exempt status of at least some religious organizations who continue to adhere to the traditional conception of marriage. Another big risk was also mentioned by Chief Justice Roberts at oral argument, and that is the prospect that that colleges, religious colleges like BYU or Pepperdine or Baylor or Wheaton, that offer married student housing could be forced under either state or federal law to offer their married student housing to couples who, in the eyes of the faith, are not in fact married. You know, the problems there could arise not just under state law, and I don't think that's much of a risk in Utah today, but it is more of a risk under federal law. You know, what's to prevent the Department of Education, for example, from issuing a regulation that says, you know, colleges that don't treat same-sex married couples the same way that they treat opposite-sex married couples are no longer going to be available for federal help for their students, like Pell Grants or federally insured student loans. Those sorts of things. Another related risk is the area of licensing and accreditation. For example, accreditation could be denied to a religious college based on its teachings or practices on marriage. And that kind of denial could either be based on state law or a private accrediting body's standards. Or again, it could also conceivably be based on a regulation by the Department of Education that says, you know, we don't want institutions that adhere to the traditional view of marriage to be accredited. Another risk is in the area of government contracts. The decision opens the prospect that religious colleges and religious service organizations will be denied government contracts if they adhere to the traditional view of marriage. For example, a religious college might be denied federal research grants or contracts into things like cartography or vaccine research or things that have nothing whatsoever to do with marriage or sexuality, simply on the ground that they continue to adhere to the traditional view of marriage. And indeed, the Obama administration recently adopted a new sexual orientation regulation that is ambiguous, at least with respect to religious institutions and how they'll be treated. And so in light of Obergefell, we could see those regulations now being extended to marriage policies. Of course, there's a general risk from employment regulation. Can a religious institution of any stripe enforce religious hiring standards with regard to marriage? You know, a stark example might be a religious college that wants to have a married couple teach about dating and marriage. Are they going to be required to hire a same-sex couple to teach that class? Now, in federal law, Title VII, which generally governs employment discrimination for federal law purposes, it has an exception or an exemption that exempts religious institutions from its requirements. But that wouldn't necessarily prevent the current administration, for example, from imposing those kinds of standards as a condition of federal funding. And some state employment laws don't have exemptions of that sort for religious bodies. And so in some states, again, not in Utah, but in some, and I think quite a number of states, state law could well be used to try to force a religious institution to treat as valid for religious purposes a same-sex marriage that has been accepted under state law. And finally is the problem that Justice Scalia mentioned during the Obergefell argument, which is our church is going to have the ability to marry their members and have those marriages recognized by the state, even if they refuse to marry same-sex couples. That is, will churches be allowed to discriminate against same-sex couples in their marriage practices and still have those marriages recognized by the state? Again, I don't think that's a problem in Utah, but I suspect we will see that issue arise in a number of states around the country before too long. Well, what can be done to dodge these grenades that I've described? And I have three general suggestions besides being civil and respectful in the way we approach these issues. Number one is I think we need to calmly and consistently explain why each of these issues in fact involves genuine religious liberty concerns. Now, you all have heard from the LGBT community that they generally respond to those concerns by saying, well, they don't implicate genuine religious liberty concerns, and when pressed, they rely on a Supreme Court decision from 1990, Smith versus Employment Division, that cut back on the Supreme Court's enforcement of the Free Exercise Clause of the First Amendment, and it said, contrary to what had been the law previously, it said that as long as a law is neutral and generally applicable, even if it has incidental effects on religion, it's not subject to any particular heightened scrutiny under the First Amendment. And so as a result of that decision, it has become much, much more difficult to win claims under the Free Exercise Clause of the First Amendment. And so when the LGBT people say, no, these don't involve genuine religious liberty issues, what they really mean is, we think you would lose that claim under Smith. Well, think about that logic, though, and how it would apply to things that the LGBT community is seeking, right? They would never accept the idea that the concept of freedom from discrimination should be limited to what has already been held to be unlawful discrimination under the Constitution, right? If they, I mean, their conception of the value of anti-discrimination extends well beyond what the Constitution itself protects or what court decisions under the Constitution have been held to protect. And so in the same way, the concept and the value of religious liberty isn't limited to what the Supreme Court has said is narrowly protected by the Free Exercise Clause of the First Amendment. And I think some of the leaders of the church have recently made that very clear, that as members of the LDS Church, we should not adopt a conception of religious liberty that's limited to just what the Supreme Court says the First Amendment protects. Now, my second suggestion is to get all of the protective legislation that we can at both the state and the federal level. And some people might ask, well, why can't existing law adequately address these issues? I've explained why the Free Exercise Clause will probably not be enough to deal with most of these issues. But why, if a state has a Religious Freedom Restoration Act, why wouldn't that be enough? Why wouldn't the federal Religious Freedom Restoration Act be enough? And in a lot of cases, those authorities and state constitutions will be very, very helpful. But the problem is that none of those authorities focuses specifically on the conflict between same-sex marriage and religious freedom, and therefore it can cost millions of dollars in legal fees to win a decision that says, yeah, that particular bit of religious conduct is protected. Is that fair, Alexander? Is it uncommon to have to spend $1 million or more in legal fees to?
I'm just surprised you're complaining about that.
Well, I think it is a tragedy, actually. I mean, there's plenty of work for lawyers like me and Alexander without having to impose those kinds of enormous costs on clients. But anyway, that's a very good reason to seek targeted protections for religious freedom in the face of same-sex marriage. And at the end of the day, and on a lot of these issues, we don't really know how, what the answer is going to be until it's fully litigated. And so that's one reason the effort in Utah, I think, was so valuable, and I hope it'll be replicated in a lot of other states around the country. It's also why a proposed statute that was recently introduced by Senator Lee and Representative Labrador from Idaho, I think could be very valuable. It's called the First Amendment Defense Act. How many of you have heard of that? It's something that's worth paying attention to. It would, I think, protect religious institutions and people of faith against the most serious kinds of retaliation that might be asserted by a federal agency. And so it would go a long way towards dealing with these institutional problems that we discussed earlier that would arise in significant part from federal law. Similar laws, sorry. Similar laws could also be adopted at the state level, and I think that would be very useful. And even governors have a lot of authority over the religious freedom clashes that their agencies can create. And I think Governor Jindal of Louisiana set a great example a couple of weeks ago by issuing an executive order that, at least to the extent of his authority as governor, prevents state agencies from retaliating against people based on their religious beliefs or taking other actions that are going to intrude unnecessarily into the religious beliefs of Louisiana citizens. My third general suggestion, paradoxically perhaps, is don't be afraid to go back to the Supreme Court on a religious liberty issue. The Supreme Court's record of protecting private religiously motivated conduct is actually pretty good. And here's we're not going to have time to go through these obviously, but here's a list of cases from 1987 to 2005, which were decided by the Rehnquist Court, and that's before Chief Justice Roberts became Chief Justice. But there were 11 cases during the Rehnquist Court that in one way or another involved protection for religiously motivated conduct, and in 8 of those 11 cases, the Rehnquist Court ruled that yes, that religiously motivated conduct was protected. One of those, one of the big losses was the Smith case from 1990. But there were only 2 other cases in which the position seeking to protect private religiously motivated religious conduct were rejected. And here's a list of similar cases decided by the Roberts Court, and as you'll see, in only 1 of those 6 cases has the court rejected the idea that the private religiously motivated conduct at issue there should be protected. And so if you calculate the percentages, which I learned the other day PowerPoint actually allows you to do, the overall results from this entire 28-year period from 1987 to 2015 is that in 76% of those cases the Supreme Court held that yes, the religious conduct at issue was protected. The percentage was a little lower for the Rehnquist Court at 73%, and quite a bit higher for the Roberts Court at 83%. Now you might ask, well, how do the individual justices treat these issues? And PowerPoint helped me calculate those percentages too. But before I show you the results for the individual justices, which of the, and here's a picture of the Roberts Court as it exists today, and 5 of the justices there were holdovers from the Rehnquist Court. Everybody except the Chief Justice Roberts, Justice Alito, Justice Kagan, and Justice Sotomayor. All the other 5 were holdovers from the Rehnquist Court. Anybody want to take a guess as to which of those 5 justices is the most protective of religiously motivated conduct? Well, Alito wasn't there yet. Clarence Thomas? Kennedy? Okay. Anybody want to take a guess as to who is the least protective of those 5? Scalia? All right, here are the results. Scalia, in fact, is the most protective of those 5 justices at 88%. Thomas is second. Justice Ginsburg is at the bottom at 42%. And as you can see, Justice Kennedy is very high, and he votes in favor of protecting religiously motivated conduct about twice as often as Justice Ginsburg does. And as you can see, we've got a couple of newer justices, Roberts and Alito, who have voted in favor of protecting religiously motivated conduct 100% of the time in all the cases that they've decided. And even the more recent Obama appointees have voted in favor of that result 60% of the time. So it's a pretty good Supreme Court for dealing with religious freedom issues. And in fact, I would argue, although I haven't done this detailed analysis for every justice in history, but my guess is that our current Supreme Court is probably the most protective of religiously motivated conduct in our history. So it's a good time to be pitching religious liberty cases in their direction, especially when what we're asking them to do is to uphold a statute, a democratically enacted statute that protects religious freedom. They almost always uphold those. The greater difficulty arises when you show up without a statute that you can rely on, and you have to say, we want you to rule in our favor solely on the basis of the Constitution. That's a much more difficult argument to make there. So the bottom line is, and to add yet another metaphor, Obergefell has opened a religious freedom can of worms. Justice Kennedy seemed to recognize that risk, and as we've discussed, he tried to convey a certain level of respect for traditional religious views on marriage, but still, it'll be several years before we know where all the worms end up. And where they end up will depend in large part on what we do about it in our advocacy to legislators, governors, government agencies, courts, and of course to the public. In all of which, I hope we'll all continue to heed Elder Oaks's twin injunctions to be civil, but also to keep standing up for our values. Thank you.